Can a hospital restrict its doctors and consultants from joining another hospital or setting up practice nearby after leaving employment? The question has now been definitively answered with a no by the Honorable Madras High Court. The court was dealing with a case in which a corporate hospital sought to initiate legal proceedings against a consultant for joining another hospital despite a clause in the contract that expressly prohibited it. Such clauses can be found in nearly all doctor-hospital contracts. Lawyers call it a non-compete clause, a non-solicitation clause. The Honorable High Court held that the non-compete and the non-solicitation clauses were unlawful and not enforceable for three distinct reasons. The first reason was that doctors are professionals and cannot be equated with other hospital employees. The second reason was that such a clause is hit by Section 27 of the Indian Contract Act 1872, which holds all agreement in restraint of trade as void. The third reason was that such a restraint is opposed to public policy under Section 23 of the Indian Contract Act 1872. There are two key learnings from this case for hospital. The first learning: hospitals can have clauses relating to notice period in their contract. It is perfectly legal, but it must be reasonable and equitable to both the parties, the hospital and the doctor. The second learning for hospitals: avoid putting non-compete and non-solicitation clauses in contract with doctors. The Contract Act is very clear, and now there is a well-reasoned judgment from a constitutional court very specifically on doctor-hospital contracts. There are two key learnings for doctors. The first one is a general one. A contract is legally binding on both the parties, and diligence is certainly required before signing one. While junior doctors may really not have a choice and will sign on dotted lines, we have observed that even senior doctors who can make their own choices can get their terms incorporated in the contract, do not even read the contract. Please read every contract before you sign. Another aspect that is clear from this judgment: notice period before leaving a hospital is perfectly legal and it must be honored. There is one more aspect, rather a disclaimer. Is this proposition of law final and binding all over India? And the legally perfect answer is a no. It is passed by a high court. It can still be challenged in the Supreme Court. Nevertheless, the reasons given by the Honorable High Court, what lawyers call as the ratio, is so strong that as and when a dispute of a similar nature reaches any other high court or the Honorable Supreme Court, the outcome will be similar. Let us not forget that the conclusion arrived at by the Madras High Court is based on the Indian Contract Act 1872, which is the same across the country. Thank you.